All right, welcome to The Explainer. Today we're going to unravel a legal case that's a century old. Now, on the surface, it's just about a fire that gets out of hand, but dig a little deeper and it's this fascinating legal detective story that makes you ask a really big question. When something goes wrong, who's actually responsible?
Okay, so picture this. It's 1922 in what was then called Ceylon. You've got a farmer, Seguthamby, who's setting a fire on his land. Totally normal practice back then, to clear it for planting. But the fire doesn't play by the rules. It jumps over to his neighbor's coconut plantation and causes a ton of damage. Looks like just a terrible accident, right? Well, the question of who was really at fault, that's what sparked this huge legal fight.
So the guy whose plantation got torched, his name was Samed. And you can imagine, he's watching his livelihood go up in smoke and thinking, my neighbor, Seguthamby, did this. So what does he do? Exactly what you'd expect. He takes him to court.
And this is where the story gets, well, just plain weird. The first judge's ruling was a real shocker. He says, you know what, Seguthamby, the guy who started the fire, he did everything he was supposed to. It was an inevitable accident. But then, and get this, he actually blames the victim, Samed. He says Samed was guilty of contributory negligence. Basically, hey, you should have cleared the dry grass on your own land. So the poor guy who lost his entire plantation, he loses the case too. How does that even happen?
Well, you can bet Samed wasn't having any of that. He appealed to the Supreme Court, of course. And this appeal pushed the whole thing up to a much bigger stage. The High Court judges now had to tackle this one. Huge, fundamental question. If you do something dangerous, like set a fire, and it causes damage, are you automatically on the hook for it? Or does the person who got hurt have to prove you were being careless? Everything hinged on the answer to that question.
So this whole legal battle really boiled down to two competing ideas. It's like a legal showdown. In one corner, you've got the English law concept of strict liability. It's pretty simple. You start a dangerous fire, it causes damage, you are responsible. End of story. But in the other corner, there's the Roman Dutch rule, which is all about negligence. This one says, hold on a second. You're only liable if the other person can prove you were actually being careless. The whole case was about which of these two rules was the right one to use. So the Supreme Court judges had to put on their detective hats. They couldn't just say, oh, we like this rule better. No, they had to go digging through dusty old law books and legal history to figure out which one was the actual law of the land for this exact kind of situation. First up, they looked at that English rule. It comes from a really famous case, Rylance versus Fletcher. And for years, courts in Ceylon had just kind of assumed this was the rule. It became what one of the judges brilliantly called law taken for granted. Everyone just accepted it without really questioning it. And hey, if that rule was the right one, this would be an easy win for Samed.
But as they started to really dig in, they realized something super important. That English rule, it was really meant for what lawyers call non-natural uses of your land. So think like building a giant reservoir. That's not something you'd normally find on a farm. Or, keeping a wild monkey that might escape and cause chaos. But setting a fire to clear farmland, back then that was totally normal. It was a natural use of the land. So that English rule, it just didn't fit. It was like trying to fit a square peg in a round hole.
So they had to look somewhere else. They went even further back in time, to the original Roman Dutch law that was in place. And bingo, they found a rule that seemed like it was written specifically for this kind of case. It pretty much says, look, if you take all the right precautions, but something totally unexpected happens, like a sudden freak gust of wind, then you're not negligent. It draws a really clear line between being careless and just having bad luck. And this felt right.
Okay, so now they've unearthed this old rule. The big question is, what did they do with it? How did the Supreme Court finally decide this thing? Let's break down the final verdict. All right, first things first, and this is huge for Samed. The Supreme Court completely tossed out that bizarre decision from the lower court. That whole verdict about it being an inevitable accident and blaming the victim, gone, overturned, wiped from the record. And in its place, the court laid down the law, literally. They made it crystal clear. From now on, the Roman Dutch rule of negligence is what counts. But that also meant the burden of proof was now on Samed. It was up to him to prove that his neighbor, Seguthamby, had actually been negligent.
But wait a second. This brings up a massive question, right? If Samed now has to prove his neighbor was careless, how on earth did he win? Remember, the first court already said the guy took all the necessary precautions. So where was the proof? Where's the smoking gun?
And this is where the Supreme Court's reasoning was just brilliant. They basically said, yeah, the plaintiff has to prove negligence. But sometimes you don't need a witness to spell it out for you. Sometimes the facts just speak for themselves. In this particular case, the way the fire behaved, well, that told the whole story.
So let's really look at what happened. Seguthamby took a precaution. Sure, he cleared a 30-foot wide strip of land in the direction the wind was blowing. Smart. But here's the crucial mistake. He didn't clear enough space on the sides. He never planned for a simple, totally predictable thing to happen, the wind changing direction. And what do you know? That's exactly what it did. The wind shifted, the fire jumped sideways where there was no protection, and it just took off. That failure, failing to plan for something so common, that wasn't just bad luck. That was a failure to be reasonably careful. That was the negligence.
So you might be thinking, why do we care so much about this old case about a fire on a farm? Well, because what we can learn from it goes way beyond just farming. It's a really powerful lesson in how the law and justice itself is supposed to work. I think one of the coolest things to come out of this whole judgment is this idea of questioning law taken for granted. Think about that. These judges had the guts to say, we're not just going to accept this rule because that's how it's always been done. Instead, they rolled up their sleeves, did the hard work, and figured out the why behind the law. That's a huge stand for making sure justice is based on solid reasoning. And what they did here, it's really a perfect masterclass in legal reasoning. Just look at the steps. 1, they figured out the real question. 2, they dug into the history. 3, they threw out the old, wrong assumption. And 4, they applied the correct law to the actual facts to get the right outcome. It's just beautifully logical.
And so, this case from 100 years ago leaves us with a question that feels incredibly relevant today. It's all about foresight, right? About our responsibility to the people around us. And it kind of forces you to ask yourself, in my own life, in my own work, am I only planning for the best case scenario? Am I only preparing for the wind to blow in one direction? Or have I thought about what happens if things change? That's a question that's just as important now as it was back in 1924.